not Newark. Not that there's anything wrong with Newark. Newark's great. And I'm here to talk about authentication of digital repositories. The scope of the kind of thing that I want to talk about today would actually apply to just about anything. And the ideas that I'm going to talk about today could apply to any kind of repository. A local repository of scholarship, web pages in general that are kept and preserved in any law library or law school or any repository. The focus, however, is going to be mostly on preservation of redistributed legal materials, things like court cases, codified material, the kind of stuff that Mr. Palfrey was talking about downstairs just a half hour ago. As a librarian and as somebody who runs a digital depository, I'm kind of standing in the middle of what's going to become, I think, an ongoing debate about the issue of authentication. When I first started as a librarian, my idea was to start creating digital repositories, particularly of court decisions and legal material. And at the time, my thought about the whole matter was that we'll start doing this, and we'll do it as an academic project. And if we do it as an academic project, it will have the cachet of the law school, the cachet of the institution. It'll be done by people whose interest and explicit interest is accuracy of the material and scholarly quality. And so the idea of authentication and officialness of the document really didn't enter my mind that much. And the sense that I had was that over time, if we start doing this and can show that it can be done and can be done in a cost-effective manner, then it could be done on a fairly wide scale. That was my idea at the time. And that the widespread distribution of material would make it authenticated and make it trustworthy. Quite frankly, my ideas on the matter have not changed that much as far as basic principle goes. We can talk about MD5 sums, SHA1 and 256 hashes if you want to, and I will be talking about them. And we'll talk about some digital signatures. But is there anything that can't be hacked? Is there a digital signature from Adobe or GeoTrust that can't be falsified? Or, if somebody really just wants to put false information out there, or if somebody just makes a mistake and then certifies the document that has the mistake in it, does that make it more accurate? Not really. Does that make it more authentic if it's just plain wrong and doesn't contain what the author originally put in there for one reason or another? Not really. What makes the difference, and again, what really makes the difference, I think, is distribution. I'm thinking about the traditional role of libraries in the course of history. We have, for example, the West Publishing Company traditionally publishing hardbound print copies of books. They may be one publisher, and I go to the one library I have access to, and I look up that case, and I get the text from there. Is there any stamp or certificate of authenticity in there? No. Does it even pretend always to be official? Quite often, no. I mean, there was a push to do that, over time. But West was a reprinter. The regional reports are not official, but they're used all the time. They're cited all the time. Why do we do that? Why do librarians accept that as a standard? Why do we download things off of Westlaw? Well, the principle, I think, is that once the one book is published, it's distributed in thousands and thousands of copies all over the country and all over the world. If you want to go through, and it's hard to doctor a print book too, but if you wanted to do that, there is hundreds and hundreds of thousands of other copies that you would also have to track down and doctor in order to get away with your fraud. So, practically not possible. Similarly, in an online world, the same thing ought to be the guiding principle as far as I'm concerned. The widespread distribution of material is what will really guarantee accuracy and authenticity in the long run. We can do all we want to with technology and with fancy certificates, but what's really going to make the difference is if there are lots and lots of copies that can be compared with the one you're using. So you can just look and see the differences. How many people are going to commit fraud altogether? How many people are going to make the same mistake altogether? And if there's a mistake that everybody's made, well, that's something that happens too, but then that's the document, right? So, that I think is the background of where we should start with this. And it's an issue now because it's something that's going on with AALL, lots of talk in the ELIAC committee about authenticity and officialness of online documents. They're seeing it because they're seeing different sources pop up, not Lexis and Westlaw and the traditional sources. And there's a question there. Okay, there's a couple of different sources. Are they accurate? Well, I'm wondering, is this, insofar as this is an authentic concern and a real question, and I assume that it is, I think it's just because this is something that's just so new. That's my suspicion. And it's something that's just so new, but also it's something that just isn't widespread enough yet. If there are 5 or 6 sources, can inauthenticity and inaccuracy creep into the system fairly easily? Well, maybe. And so at this point in history, I think the question of authenticating our documents and tracing them back to an official source is something that people who create online repositories really should be concerned with. I'm hoping that this concern will go away after a while. And I expect that it might, if we're successful in the long run. But right now it's a concern. It's a concern too, thinking about the idea that it might not be successful in the long run, because what's the alternative? The alternative is, you know, a duopoly of Lexis and Westlaw as the permanent choices for authentic legal material. And I think that would actually be a disaster in the long run. It can.
John, what? I don't know how much you thought about this. Actually, I haven't given it much thought. What does the role of judicial notice and what courts are willing to do regarding possibly changing judicial notice of primary sources have in this process?
What do you mean as far as judicial notice?
Well, judicial notice in many cases operates to say, you know, what if the legislature hasn't acted and said what's official, and the courts may, by rule, say this is what we're going to do. So take notice as being the law of the state in terms of primary statutory sense.
I think that's a basic start. And that's actually something that's going to be at the beginning when I start actually talking about the process of authentication. That's where everything really does have to start. And that's of key importance. But even if, you know, there's an official source and it's completely redistributed through Lexis and Westlaw, what do we have? We have 2 points of failure for the entire information system for law in this country, which seems like madness to me. You know, you can talk about Lexis and Westlaw never, ever going out of business for the next 200-300 years. I mean, they're a huge company. They're very successful companies. Just like GM. It's never going to happen. You know, and even just on a shorter term, could it ever happen that the New Jersey reports just aren't going to turn a profit for Lexis and Westlaw? Never happened, right? I mean, it did happen with the New Jersey administrative reports, but that's just a small thing, and it doesn't really matter, except for the thousands of people who rely on it. But you know, this is something we need to be concerned with. And the only way that we can ensure preservation of information is through redistribution. And at this point, to the extent that we are more and more relying on a small number of commercial vendors to supply us with all our information, we are giving up our role as the distributed preservers of information in our libraries. As soon as we stop collecting those print books and rely on Hein Online for our journal collections, the distribution has stopped. Everybody has access, but distribution has stopped. And we're down to the 2 or 3 points of failure in the entire system. And nobody cares about this, except us. The professors don't care, because as long as Hein Online is there, it doesn't matter to them. The law school administrations don't care, because as long as Hein Online is reasonably inexpensive, and Lexis and Westlaw, it doesn't matter to them. They're not paid to think that far ahead as far as legal resources are concerned. The only people who are paid to think that far ahead are librarians. So we have to do it, and we have to take it seriously. No, we're not. But if they paid us so much that they had to listen to us, that might make a difference. So what I'd like to do now is talk a little bit about, again, in the context of public access documents, particularly court decisions, just as something to key in on here. Talk a little bit about the kind of the intellectual procedure and flow of what we're talking about here, and how we can handle such a system. To start out with, we have the users at the end, librarians and end users like lawyers, the public, businesses, and other people. The fact that this is a long list here is important. So what do they want? They want information that's accurate, trustworthy, admissible in court, judicial notice or whatever, and they want it to be easy to get. Now, where do these things start from? What's the origin? Well, right now, the de facto source for everybody is an official or semi-official document from an official government source. Right now, they usually don't label them as official, and again, AALL with the ILIAC committee has been doing a lot of work trying to document this, going through the states, who's designating their online sources as official and what's not being designated as official. Most of them still won't take the step and take responsibility for the information they're putting out there and label it as official, which is odd because, to my knowledge, Lexis and Westlaw, they don't want to spend a whole lot of money getting their material, and they're taking it from the same place and then reformatting it and editing it just a little bit to make sure there's no typos, and then printing it. And that's the official copy. But they're getting it still from the court website or from some other court source. So we need an official designation. We need things to be guaranteed as accurate. And right now, the only source I know that is really taking this seriously and trying to do something about it is the government printing office. And at this point, it's still experimental, working with different signatures on their documents. So I just have here one example. They're putting in SHA1 and MD5 sums, digital signatures. One thing that's striking me is very odd about the whole system that they put in place is that they're using Adobe and GeoTrust to provide them with the digital signatures. So we have the official government repository, the government printing office, putting stuff on the government printing office website. And then Adobe has to tell us that it's authentic. So, just to see an example of what we're talking about here. Here is a congressional resolution, and we have a wonderful, I'll use the mouse for this, we have the wonderful bug that they put in place, and this is hypertext linked. And we can see the digital properties of the document. A summary, what kind of digital signature it has, and it can be validated. And if we poked around in this enough, we could actually see the digital signature that's in here. Let's see if I can get it quickly through the panel here. Come on. So if we dig, we can actually get the SHA-1 digest and also an MD5 digest. Wonderful. These are actually, this text here is the actual digital signature that's being verified by GeoTrust through Adobe, which is good. The question I have in my mind is, you've got a good proof of authenticity. You have actually fabulous proof that's very easy to access here, and there's advantages to all of that. This costs money to put together. It costs money to maintain. I have questions in my mind whether this is all really necessary to go this far as authenticating a document. Because again, the question is particularly if this is redistributed material, is this really that subject to fraud and really that subject to mistake that we really need to lock it down this much? I mean, to a certain extent, it's something that I've seen librarians do over and over again when they start doing digital repositories and when they start amassing material that's not a typical book. One of the things we quite often do, and I've seen done over and over again, is starting a digital repository and generating MARC records for everything. And again, it's a question of serious overkill and serious expense, which in the long run makes the whole system unsustainable. One example of this, I know particularly, is there is a university in Philadelphia that has a wonderful collection of photographs of Philadelphia history. And they got a very large grant to do it with from the government. And again, a fabulous system. But when they planned it, they said, okay, we have to have a MARC record for every single one of these photographs and put it in the catalog. And they ran through their $5 million or so so quickly with cataloging information that they actually got only a small number of their photographs cataloged. And then the government looked at this and said, that's wonderful cataloging, that's it for your funding. And that was that. Again, this kind of thing here is wonderful, but is it something that you can do for every single bill and every single public law that ever comes out? Is it something that every single redistributor that may want to mirror this information can do? What is that going to do to the internet even? Imagine all of these digital signatures. I think we can streamline this quite a lot. So what is enough authentication? Now, my one beef too with the American Association of Law Libraries, as far as this whole topic goes, is for everything that they've written and talked about at this point, their entire concern seems to stop at this point. Now, to the extent that this is a great concern and this is going to be the source of redistribution of information to anybody who wants to mirror and wants to be a repository, it's important to authenticate and make official at the official source. But that's only the start of it. What are we going to do with the places that redistribute? And I think this is an important question because even though AALL doesn't really pretend to talk about anything beyond the official source in a certain way, it's implied. There's a strong, I think, implied criticism of every other source that's out there. Because as soon as they talk about the official source and the authentication from the official source, then they start talking about, well, what about errors creeping in from other sources? And it's talked about all the time, as far as I can see, and from all I've heard in every conversation I've had on the topic. Which brings me to everybody else. Commercial databases. Like I said before, Lexis and Westlaw take stuff from the internet just like me, and just like everybody else, just like Mr. Stanley and Mr. Bruce. We get it from the official source, we clean it up, we add value, and we redistribute. And again, one of the other things that I would like to talk about, I'm going to try and be done in about 10 to 15 minutes so we can have some time to talk about this. One of the things I think is important to talk about is once you've got an authenticated document, the problem with it as far as the AA/LL attitude and policies that are evolving in AA/LL right now is the fact that there is absolutely no room in there for alteration or value-added features being stuck into a document. Because once you do that, you can download something and leave it just as it is, and a certificate will remain valid. But once you try and put in hypertext links, once you try and insert useful meta tags that will ensure long-term viability of your archive, in other words, doing things you absolutely must do to preserve the thing properly, as well as add value to it, the certificate from the official original source is useless. And so we have to address that. AA/LL needs to make room for it. You really need to make room for it. And everybody who's engaged in redistribution needs to think about it and make room for it too. So what do? Nonprofits, academic libraries, commercial databases, we all download from a trusted original source. And then the next part of the process is distributed availability and archiving, which I've talked about already. The importance of distributed repositories to ensure the viability and ensure the authenticity long term. But then, something that I think is absolutely crucial, but again, we haven't talked about much in terms of AA/LL policies or things in general, is value-added features that are absolutely necessary to ensure accurate and viable archives, and actually also to ensure availability of material, finding tools that you have to put in there, varied search engines that different people can use for different purposes. The more, the better. Hypertext linking of documents. I don't know of any official original source that has any significant degree of hypertext linking in their documents. Particularly for court decisions, this is crucial because they're riddled with citations to other decisions. And to have to read the decision and then go on a completely separate search for the new document is something that's, I mean, number one, it becomes impractical very quickly. Number two, it's just plain crazy not to do it, if you can. And we can. So let's do it. Serve the people who are using the material. The advantage of having collected content is something that's also crucial for effective legal research. You can have GPO as a fabulous initial source of material. They have lots of stuff. But then there are the courts, and then there is, then there are the administrative agencies. Outside third parties can aggregate all of these and make them work together. Value added. I mean, I'm talking about the kinds of things we just don't even think about in terms of Westlaw and Lexis, because that's their business. We can all do it. And to the extent that other people do it, it's important. So, rich tagging, varied interfaces. We all try and make things as usable as possible. One of the things I saw recently, which I thought was very encouraging, is the new interface that Bloomberg is going to try and come out when they roll out their case law system, which I'm not sure, does anybody know whether it's actually available to the public yet?
It isn't. It's not there yet.
Yeah, earlier this year. Yeah. Yeah, earlier, actually, we were both at the same thing at Penn a few months ago, and they were giving a demo of it, and it was wonderful. A very different kind of interface than Lexis and Westlaw, in a lot of ways a lot more intuitive, if they can get it together and get it out, which I assume that they will in the near future. It'll be a wonderful new way of doing it. Varied interfaces, multiple formats. If you want things in PDF, well, that's fine. But what about HTML to make it easy to search and scroll through and easy to hypertext link? What about word processor formats to the extent that people want that kind of thing? My users tell me all the time they still want the Word document that I originally downloaded. Well, fine. They should be able to have it if it's available. And finally, and last but not least, price points. I don't think I'm ever going to replace Lexis and Westlaw. I have dreams of it because there's a little bit of a megalomaniac back there somewhere, but it's not going to happen. But what I can do is make a wonderful system that's going to be good for my students and good for the small and solo practitioners in the state of New Jersey, and is going to be wonderful for general members of the public who have absolutely no real access to Lexis, Westlaw, or anything else. And I can make it as usable as possible. And I can also save a copy forever, so that when Rutgers finally stops collecting reporters, which is going to happen in my lifetime, actually well within the course of my career, I'm sure, Rutgers is still going to own a copy of all of the federal second, all of the federal third, the New Jersey reports, the New Jersey super, the New Jersey administrative law reports, the U.S. code, and whatever else I can drag into the system by the time I retire. We're going to own it, not just rent access to it. By the way, if anybody else wants to own it as well, just ask me. You can have a copy. Pardon?
You'll never replace Lexis.
No, and why would we want to? They do excellent work with what they do, right? And they can bring resources to bear that I'm never going to have to make a wonderful research tool that I'm just not capable of doing. And that's fine. And it's going to be worth money. And they're going to make money doing it. So, authentication of redistributed text. I lost a little tag here. I'm going to put it right back down. There. So we're complete again. What do we need to do in order to guarantee to the public at this point in our history that material that we redistribute and that we mirror is as trustworthy as Lexis and Westlaw, even if it's not as easy to use, even if it doesn't have as much value added as they have, even if we don't have the long-term quality control reputation that Lexis and Westlaw have at this point? Well, I think the first thing we need to do is, number one, preserve the original digital signature. And the overall idea that I have here is the question of tracing back, showing and the word just popped right out of my head, Anybody who's interested in antiques will talk about provenance. Thank you. Thank you all. Preserving provenance. To be able to trace a document back to its origin, so that if you have a question about the authenticity of a document you're looking at, you can figure out what's going on. Now, this is important because at this point, I mean, I've talked about this with several people, and I made a blog post about it on Vox Populi from Cornell. And some of the comments I've got back on it was the practicality and usability of the kind of system I'm talking about. That it's too clunky and it requires too much technical knowledge. And quite frankly, it's not something I'm really that concerned about. And the reason why I'm not that concerned about it is something that I already mentioned, is that how much serious doubt is there really concerning any of these documents from any kind of reputable source? Anybody who uses the Rutgers system or Justia or the Legal Information Institute knows that these are institutions that are concerned with accuracy and that are taking care because at the very least they need eyeballs to be brought in. And if they get a bad reputation, they're not going to have eyeballs for very long. So the question I have in my mind is, if you have a question about a document, not assuming that there are questions to begin with. And I think that's a very different approach to the whole situation, and it makes the whole situation amenable to much more inexpensive and easier to do and practical to do for all kinds of institutions. Practical solutions. So, preservation of the original digital signature is something that's easy to do, can be done right off the bat. I talked earlier about embedding meta tags to make something more amenable to long-term archiving. The identification of the document needs to be part of the document when you're talking about long-term digital archives. You can have a database over here with all kinds of wonderful meta information. You can have a full-blown catalog record, but if that wonderful database with its rich set of data and links to a document, if that link ever gets broken, which happens, then you've got a whole lot of useless data files and a completely useless database over here. However, if you embed the data, which is one of the reasons why I like HTML so much, not so much PDF, although it's doable, embed the data. One of the things that you really ought to embed in the data is the original digital signature. Initial stage of value-added processing. Implement also, on top of that, TEI or a similar system to explain the document and explain the provenance. And then generate a new digital signature to authenticate the new document. So what am I really talking about here? Let's again look at an example. This is a document from the New Jersey Superior Court Appellate Division, and it's something that we downloaded a little while ago. It originally gets downloaded in Microsoft Word format. Not great for searching, not great for putting on the internet, not great for automated hypertext linking. So we convert it to HTML, and that's what the people see. And if you want, you've still got that nice link to the original Word version. And again, hypertext links, they're all wonderful, and they all work. But embedded in this, and if we can just look at the source code of this document, the source HTML, the important stuff is right here at the top, in the header tags. A full set of header information. Actually, I can't see that at all, so I'll just point with the mouse. The original docket number, the date of decision, again, the first paragraph of text, which is practical for me to download, but getting down here, we get to the kind of stuff that I'm talking about right now. The original MD5 sum. Now, The New Jersey courts at this point aren't bothering to generate these kinds of things and aren't supplying them to me at all. So one of the things that I do with processing when they initially get downloaded, as soon as I get them on my server, is I run the MD5 sum and then save it, and when I convert the document into HTML, I immediately embed it there. So you can trace it back. You can download the original Word document right from the state of New Jersey, and you'll get the same MD5 sum. Going on just a little bit beyond that, not too hard, is these are actually very cheesy adaptations of the TEI light schema for metadata for documents. The revision date. This is the date we downloaded it, date and time. And here is just a short basic description of what we did to the document, what we originally got, and basically what we did with it and the program we used to do it with. So, what can you do with this information? If you have a serious question as to the authenticity of this document, if there's a piece that seems missing, if there's a piece that's unexpected, if you've got a serious question, you can look at these meta headers and you can trace it back. You can see we downloaded it from the Administrative Office of Courts as a Word document. We used WVHTML. Well, we all know that that's a highly flawed program now, and so that's where the problem could be. It's not actually, it's a very good program. Citations converted to hypertext links, and here's the original MD5 sum. Download the Word document from the courts, see if it matches. If it doesn't, you can tell me, and then I can fix it. But it's an easy way to, well, it's not easy. Admit that, it's not easy. You have to take some steps here, and you have to have some knowledge of what's going on. But you can trace it back, and you can re-authenticate. The one step beyond that is I talked about saving once we've converted, added value to the document, embedded all of this material that we need to guarantee archival quality to the metadata so that we can save this long term and that the document can identify itself in a useful way. Then the next thing we do is generate a brand new MD5 sum for the brand new document that we've just created. And that, of course, you can't embed in the document. You've got a chicken and egg problem with that. But that we can at least save in a database and make it available to anybody who wants to. If this gets redistributed beyond here at this point, well, then anybody who's going to mirror this information is going to want that subsequent MD5 sum to check that, to check the authenticity of the copied document. It's there, it's ready, and it's available for anybody to use who wants it. And this is basically the metadata that we lift out of the document when we originally downloaded it. Finally, as to the practicality of doing things like generating MD5 sums, generating SHA1 sums. I have been asked how complicated that is. And this file here that we were just looking at is called example.txt. Now, this is a fairly short document, but nevertheless, that's how long it takes to generate an MD5 sum. And a Perl script can do it to 1,000 documents in about 3 or 4 minutes. That's a free utility that comes with the operating system I have on this machine. And it takes about that long to generate. It's very practical for anybody to do it, and doable on a very large scale. Again, we were talking earlier about when I was showing you the congressional resolution. The kind of certificate there that they have is wonderful, very detailed, very comprehensive, costs money from a third party, and again, how practical is that to do on the kind of scale that will be at all meaningful in the long term, especially for a law school library for a small institution that's trying to get itself off the ground and be commercially viable? Well, not so practical. But this kind of thing is practical, very doable, and is a good guarantee of the accuracy of the document. So again, objections that I've heard. Actually, let me hide the big one right now. It sounds expensive to implement. It's actually free. I've been told that it's complicated. It's actually largely automatable. And in fact, as far as the tags that I've been talking about right now, in the system we have at Rutgers, it's entirely automated. And we don't have to touch it now that it's set in place. And finally, no user can use the abstruse digital signature technology that's available. That's largely true as compared to the kind of digital signature that, like the GPO, is making available. But again, there's big cost there. And my big question about it is it really worth all that money if it's still available from the original source, if it's available from 5, 10, 15, 500, every single law library in the country mirroring this material because they have a need to own the material and not just rent access when they finally stop buying the print, which many, many will in the next 5, 10, 15 years. This is viable and it's doable. And to the extent to which there's a serious question, well, if there's a serious question, then having to have something so easy to click on doesn't seem that important. We can go in and we can check it if we need it. But for the most part, it's wasted money. How many people are actually going to be concerned with going through all the details of that digital certificate that Adobe is generating for all of these government documents? Nobody. We're mollified by the fact that the bug is there and we can click on it and get this certificate. Quite frankly, them stating and telling you that the digital signature is embedded and usable when it's needed would be, to a great extent, equally mollifying. It's not as mollifying, but it's mollifying enough, and I think more than enough, to justify doing. So those are my ideas on the issue. If anybody has questions or fanatic objections?
As a leading falsifier of official documents, I can agree with your position entirely. I gather that some of what you're saying here is basically an insurance argument, right? That what people are willing to spend to do these things is directly proportional to the value of the goods and the perception of risk.
Absolutely.
And to that extent, I absolutely agree with you. There are other people who have this problem. Digital repositories of scholarly materials that are aggregating multiple data sources for metadata have dealt with this for some time now. They have inexpensive automated techniques for dealing with it. And they've even gone so far as to automate some of the stuff that you have automated locally on a much larger scale, saying, look, there are certain transformations that everybody's doing to these documents. We can sort of have a catalog of those and a set of known practices that we can actually record in metadata. All of those strike me as very useful.
Yeah, and I mean, we had talked about this before, you and I, about and written to each other about the TEI headers. Mm-hmm. I mean, I showed you my cheesy adaptation of them to make it quick and easy to put in court documents. And the court documents don't really fit into the TEI schema very smoothly, which is a problem with a lot of good schemas. But TEI itself is a very widely used and very well established tagging system that's got a very robust set of tags for provenance and for authentication. It's right there, and again, very easy to use. And it works very much along the lines that I'm talking about here. We're not talking about gigantic, expensive digital signatures. We're talking about embedding the data you need in order to figure out where the thing came from, so you can figure out exactly what it is and what was done to it.
I guess the question I have, I'd throw it open to any of the very few librarians who are in this room. I say very few proportional to the amount of bitching that's been done about this issue. Why is everyone so resistant to functionalist approaches? This is the thing that has puzzled me about this for years, that no one wants to take a practical approach to this. Everyone wants to say, well, we need official blessings and people dispensation.
I don't know, Wes
why
never
is
did
that?
it. Wes never did it, not really. He just started publishing and started getting permission and established a reputation and started becoming the official publisher as an outgrowth of his activity. And I think that would be wonderful for everybody to do. And if we show we care, maybe we'll actually be that in not too long a time.
I just want to ask a question just to make sure. Okay, you have the embedded digital signature from GPO, and then you do, you change things, and then you talked about adding a new digital signature, but it's, what you're talking about is something different than like a GPO digital signature. I mean, when you say digital signature, isn't that a specific,
A digital
art that means, something that...
Well, a digital signature is, well, let's take one step back and really talk about what they are just briefly in broad brush terms. A digital signature is, it's basically an algorithm that's applied to the content of a file, which results in a signature, a string of digits and letters that's going to be a unique string for that content, right? So when the GPO generates that signature and that certificate, the basis of the certificate is the digital signature, that string that's in there, the MD5 sum. Right? As long as you don't make any alteration to the contents of that document, that signature will be valid for that document. You can change the file name. You can change the time and date on the file, when you do a dir command and look at when it was created. But if you touch the actual contents of what's in that file, that digital signature will change. So when I download documents from GPO or when I download documents from the New Jersey court system, the New Jersey court systems, I get a Word document and I'm going to convert it to HTML. Well, when I convert it to HTML, the entire content, the text is the same.
Right, but everything...
But the contents of the file, the HTML tags, the hypertext linking that I insert, all of the meta tags that I generate and then insert into the headers, it's a completely different file as far as the digital signature is concerned. And so that digital signature is not, the original digital signature is not valid. So I generate a new one so that anybody who wants to then recopy my stuff has something to go on. When they download my copy, they can have the old digital signature from the court, my digital signature, and then if they want to do any improvements on what I did, they can generate another one. And you can trace it all back step by step.
So what you did is a digital signature. So GPO handles their digital signature one way
Through their
GPO
certificates,
does
yeah.
Adobe, you're doing yours a different way, and so...
Right.
And your way, as you see, is more practical and less expensive. And
It's the only practical way that I can do it for my repository, just for financial and resource reasons.
and what is the
And
issue?
I think
is the issue between the two different types of data?
No, well, the issue for me is what's good enough. And quite frankly, I think my system is more than good enough for the GPO, particularly. It's even more good for the GPO because GPO is so trusted in and of itself. Why are they going through so many
theirs
hoops?
is a little bit different type. Theirs is
Right.
a higher trust
But I have absolutely no objection to what GPO is doing. If they can afford to do that, and if they can maintain that kind of system on as large a scale as it will need to be for GPO, I think it's fabulous, and I really like it. But I can't do it. But I can do something that's more than good enough. And so that's what I'm doing. Ken, did you have your hand up?
I was just
And then
going
you, sir?
to, in partial response to Sally, the flip side of the issue between the two signatures, for example, is how much work does the person reading it have to engage in to
Because when you do
to
GPO,
process it?
you can.
You can just look at the certificate right there. In John's case,
You have to
you
go-
independently regenerate the MD5 hash to make sure it matches up.
Right.
Right, and, you know, the question is how many of us as librarians who are sensitized to this kind of issue and who think about it, how many times have we called up, any librarian in this room, when have you called up Westlaw and asked them about asked them to authenticate a document you printed out from Westlaw? Nobody ever has, and nobody ever will, right? So how often does it practically become an issue in our lives or the lives of any real user? Yeah.
Well, I think too, from the librarian's perspective, oh, I'm sorry.
I'm just wondering, for practical purposes, do you ever validate the digital signatures you're getting from GPO? Or is it just implicit trust?
I implicitly trust them.
Do you know,
Initially, yeah.
I mean, I think we have that feeling with like this and that's why, but error correction in print and electronic is a full-time job. So
Yeah.
when you talk about being able to track your digital signatures over time, on any given document, no matter how much we trust them, there's tons of error correction. And this is sort of an artificial control that gives us comfort that we're never going to use.
Well, right. I mean, and that's the problem I have with this whole system altogether. It's an entire system that we'll so rarely use that why should we spend thousands and thousands of dollars on it and resources that we don't really have? Even in the case of GPO. GPO is not limitless in its resources. How much could they be doing if they didn't worry about this so much, right? And they could be doing a lot more. I mean, they've got a lot on their plate. You know, but the fact that they're doing it, and if they can really afford to do it, it's great.
I just wanted to kind of follow up a little bit, sort of on what Tom was talking about. It isn't necessarily that the librarians are demanding authentication, right, or the trust source. It's, from our perspective, a lot of it is from what the court says. So when we're teaching, you know, if the court hasn't recognized these resources as being official or reliable, then that puts us in an awkward position of saying, this is a great resource, but I can't tell you how the court's going to react if you cite it. They may say, I need the official source. And that's where the Lexis and West
Right.
law come in the sense of it's
Right, the court's
accepted by the
perception
courts.
of the
Right.
courts. Yeah.
Right.
And a lot of local courts will tell you that.
Yeah.
Before it's like,
Exactly. So it isn't that we're against it, it's more of, for the practical purposes of how we're instructing students and what's really practical for them.
Yeah, and you know, and again, over time,
Hopefully that
we
will
need to
change.
see this change. And if we can
Yes.
give them a good reason why they can be
Exactly.
comfortable with that change, all the better. Tim?
And we sort of follow on that. Yeah, I think one of the issues that are sort of almost right aggregate itself at the same time is a lot of times you can't get the official case. The official case is actually only on West. And it doesn't come back to the court system, so they have the slip opinions there.
Right.
But that's it. And you do like fast case laws, which is triple key in. But there is no way you can actually authenticate anything. You certainly can't get into the West case and authenticate that because it's a secret thing. So, and the best you could do is try to triple key it and sort of go forward from there. And I don't know if there's a way around that. That's just trying to get the courts in. You know, I'd like to see this, the federal appellate courts just put up their final official case. They could just do that. Maybe the states would fall in line.
Right, well, I mean, that's the biggest problem we all have, including Lexis and Westlaw for that matter, is that GPO is working on this, but even on GPO, it's available on only a very small percentage of the materials they make available. The courts don't do it at all. I mean, you know, every day I'm downloading dozens and dozens of decisions that I'm putting on my website. They're not authenticatable in any meaningful sense, except that once I download it, I can generate an MD5 sum of what I've downloaded and try and work from there, doing the best I can with what I got.
If you're having a triple P it, then
Yeah,
that's.
the slip opinions aren't even official, because, they
Right.
get small checks, and sometimes those fixes are significant, like granted to deny, or words like that. And they do it all the time, and then the only way to get it is through West, or through someone who should. So at least on the New Jersey side, it sounds like they have the official opinions on it. Or those slip opinions.
Well, they don't talk about them as official. They won't identify them as
Do
such.
West and Lexis make changes to the decisions and their published versions?
Officially, well, what happens in New Jersey is they're put on a restricted access FTP site, and then they're downloaded by everybody who's going to republish. Lexis, Westlaw, me, the New Jersey Law Journal, and on a fairly regular basis, we get emails from the New Jersey Administrative Office of Courts telling us that there's been a correction and that they're posting a new document on the website, a replacement document. And then the document just gets replaced when I do the next update.
And I sort of quick on this. One is, that's another thing that we face a lot, is that you download one version of the document, they don't tell you, and then they update it, something's been redacted or something's been changed. So you can easily end up with two different versions of the document. You actually, no reason to get the file size, right?
Right.
That's a really rough way to do it, versus decent. But that happens quite a bit as well. And then the only final thing that I was going to mention was, I think the stuff that you do in file patching, that's worthwhile, even if it's just for trust purposes, because there's a lot of hackers out there. If they just know that someone's done something, they aren't going to try to play around with it. So it's just the fact that it's done. It actually reduces the probability that people have spent a lot of time playing around with it.
Deterrent or something.
Yeah. And so that part I think is really
Yeah, you know what actually really drives me nuts? I don't want to go on the rant here, but a lot of the circuit courts, they're actually posting corrections too. I know you deal with this all the time too. And all they post is the correction. And then, you know, how do you deal with authenticity in that connection, you know? They say just change this to this in line number and paragraph, and that's the document. And you know, when you're trying to do it in an automated fashion because you have one or two people trying to do the whole thing, you tear your hair out and, well, we do our best. Thank you all for your time.